Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Red Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional, providing practical privacy advice to overwhelmed companies.
Hello, Justin Daniels here. I am a corporate M&A and transactional attorney, equity partner at the law firm Baker Donaldson. I am passionate about helping companies solve complex cyber and privacy challenges during the life cycle of their business. I am the cyber quarterback, helping clients design and implement cyber plans, as well as help them manage and recover from data breaches.
And this episode is brought to you by Ding, Red Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there is greater trust between companies and consumers. To learn more and to check out our best-selling book, Data Reimagined, Building Trust One Bite at a Time, go to redcloveradvisors.com. Well, today is going to be super fun because why are you laughing at me? I haven't even gotten started.
Because you're extremely chatty today. Have you had a lot of coffee?
I only had my one little coffee mug. It's because I got up really, really early.
Okay, if you say so.
And it's Friday.
That it is.
Well, it might not be Friday to when you're listening, but we're going to get started because we have a lot to cover.
Apparently we do.
So we have Rohan Massey, who is the leader of the privacy and cybersecurity practice at Ropes & Gray, based in London. Rohan specializes in advising on complex global data protection and security compliance programs. His expertise is on the intersection of the extraterritorial scope of national data protection laws and data transfer issues for multinational organizations, which is exactly what we're going to talk about today. Woo-hoo.
And I might have to pull an audible and ask a little bit about the EU AI Act.
No, we're going to keep it focused. You can have a different conversation.
Okay.
But you can get us started.
So Rohan, welcome to the mayhem here on a Friday with the espresso shot over here and myself. Could you give us a little background about yourself and your career journey and how you got to where you are at this point?
Sure, I will. Good to be here. Thank you very much for inviting me on the show today. So I started off as an English teacher in Japan in the mid-90s. So I don't quite know how I ended up here, but it has been a long and fun journey. When I was over in Japan, I started using a thing called email. It was very new then, on a very slow dial-up internet connection. I came back to the UK talking about more and more about the internet, and people looked at me a bit blankly. And then sort of moving into law, I was put in the technology group and asked to deal with all things related to the internet, which included at the time a very dry area of data protection notices. So I started drafting those notices, and more of them came in. And it was pretty soul-destroying work, to be honest. But then something happened in 2007, I think changed the world, which was the invention of the iPhone. Data went crazy. My practice exploded in the data space. Regulation of data, personal data, and security of data has taken invariable leaps in the last 10 years. And that's where I've ended up today, practicing in both data and cybersecurity.
Well, speaking of interesting hops and journeys, the ability to try and move data between the EU and other countries has taken a lot of interesting twists and turns. And we're going to really focus on the movement between the EU and the US, because we now have kind of a third iteration called the Data Privacy Framework, or the DPF. And many people listening will understand what that is, but let's kind of do a level set. Can you explain what is the Data Privacy Framework and what does it mean for companies?
Sure. Probably best to start with the data protection regime in Europe. So personal data in Europe is governed by the General Data Protection Regulation, which basically says you can free flow personal data around Europe quite easily and with no barriers. But if you take it outside of the EU, it has to have the same protections as being on the inside. So that's what we're looking for on a sort of global basis, and the fact that data now does move seamlessly through borders. So we're looking for it to be protected. Yeah, there are certain ways of doing that. One of the ways is by putting in contracts where two organizations agree to meet the requirements of the data protection of the GDPR. Another way of doing it is that the European Commission looks at a state or a jurisdiction and says, actually, the laws that you have in place reflect what we have in Europe, so we will whitelist you and give you what is called an adequacy decision, meaning that data can flow freely to your states as well. And then we have sort of other models for organizations called binding corporate rules, which basically was a group of companies has the same ability to protect the data flowing within the group. So when we look across the Atlantic, there was never an adequacy decision for the US, one of the main reasons being the US does not have an omnibus approach to data protection as we do in Europe. You know, Europe has this very broad regulation that covers any data that identifies an individual. The US doesn't have that. It has quite a sectoral approach. So it may be financial data, it may be health data. It doesn't have the omnibus general approach. But obviously, transatlantic data flows are critical to the digital economy. We saw the growth in the last 20, 30 years of tech businesses on the west coast of the US. We have to have a means of getting data across the Atlantic. So a decision and engagement was involved, whereby we've created what was initially a safe harbor, where organizations in the US could represent and certify to the US government that they would meet the European requirements. They went on a public list, and then anybody from Europe could transfer data that was in scope of their certification freely to them without having to take other steps. So that's basically where we end up now, with exactly that same principle framework that started off with the safe harbor, went to the privacy shield, and is now in the framework whereby US organizations certify that they will meet the data protection requirements under European law and go certified to be on the list. Once they're on the list, personal data can be transferred to them.
It was a big party over here when that news broke. So there's many companies very, very excited that this is back in motion.
Indeed.
Indeed.
So the DPF impacts companies whether they certify or not. Can you talk to the audience a little bit more about the details of some of these impacts?
Sure. So the reason that we're at the DPF now, the Data Protection Framework, is because there was a challenge under the previous two models. So under Safe Harbor and under the Privacy Shield, a European individual called Max Schrems challenged the validity of the actual Safe Harbor, because he was saying that actually in the US, we know from the Snowden leaks that there was sort of mass inception of data by the US intelligence services, and that certain rights of redress for individuals were not being adequately met when the data was in the US. Therefore, no matter what was said, it wasn't being given the protection that was sought. And the European Court agreed with him, which is why we found the Privacy Shield and Safe Harbor both invalid. So in the negotiation and development of the data privacy framework, these specific areas have been looked at and addressed. So there has been an executive order signed by President Biden that came into force to put in place certain limitations, both on national surveillance to ensure that there wasn't the sort of mass indiscriminate surveillance that was being used previously, and also to create a court or an ability and mechanism for redress for individuals. So these two areas are really important, because they're important not just for the framework, which they now support, but also because when the framework went down, one of the other mechanisms for international data transfers, the standard contractual clauses, was found to be valid, provided you did an assessment of the jurisdiction to which the data was being transferred to where the other recipient entity was. And you had to look at their jurisdiction and say, is it still adequate? Is it safe? Does it have mechanisms in it for all these sort of things? Now that we've got the US position under the framework saying, yes, we do have a redress system. No, we do not have indiscriminate mass surveillance. That actually covers everything, not just those on the framework. It will also support those using SCC. So they can look and say, actually, when I look at the risk for the data going to the US now, it's not as high a risk because we know that there is the executive order in place with regard to minimization of surveillance. There's also the redress system in place that I can use as well. And that will support all organizations. That's a real benefit. We will have to see how far this goes. We haven't yet seen it in practice. But I think that's going to be really important. It will make reliance on standard contractual clauses a lot easier, which in some cases is necessary.
A lot of companies that I have seen, they have been asked by their clients to house the data locally in the EU. Do you think you will, I don't know if you're either hearing from companies that this will still be a practice, or do you think that there will be a little bit of a shift away from that, given these new frameworks that we have?
Yeah, I think it's kind of a commercial answer, because I think from some jurisdictions we saw when the privacy shield was found invalid, basically, well, there's no real way you can transfer data safely to the US now, even if you're using standard contractual clauses. So for that reason, the data should stay in Europe. I don't think that's actually right. It is quite clear under the GDPR that there is an intention to allow data to be shared internationally and to travel internationally, provided that it's protected. So I think that the fact that we now have a system in place that hopefully will be robust enough to ensure that there's a sort of long life to the adequate levels of protection under the frame, but it should allow for much greater sort of data flows, and for organizations who actually commercially it's sensible for us or efficient for us to host this in the US, and we can now host it in here adequately and with that sort of confidence. One of the troubles that organizations have faced for the last 5 years now is the constant change and threat of not knowing. We've used the privacy, we went from safe harbor, we used the privacy shield, then we had to use standard contractual clauses, then a new set of standard contractual clauses were brought in because of obviously the old clauses predated the GDPR, so we had to change again, and all of that is cost and administrative time, and I think that's commercially a frustration. So where organizations can sort of think, actually, we now have a robust mechanism in place, we will benefit from this, it will be efficient, and it will be cost effective for us because we won't be having to change it, then they'll use it. And I think that will allow for data to be housed in the US, or should allow for it.
You bring up a really good point. I have some very tired clients, and I hear the frustration all the time and confusion. Which one is it? What am I supposed to be doing? I'm excited to see how this will play out as well.
Well, Rowan and Jody, I kind of have a different follow-up question, and it's this. So GDPR came out, what was it, 2017?
It was effective
2018.
You did not have your coffee today.
Clearly, I need some coffee. And all of these laws are predicated upon the EU ability to enforce these laws. So, Rowan, I was wondering if you could talk a little bit from your perspective in London about the history so far about enforcement, some of the fines, because if I'm Facebook or Google, that seems to be one thing, but let's say I'm a mid-market company that is multinational, and I say, well, Rowan, I appreciate what you're saying. Jody, I appreciate what you're saying, but what's my real risk here in terms of enforcement?
Yeah, great question. And look, I think we've seen over the last 5 years certain trends developing within the enforcement actions taken by the DPAs. We know that if there's 1.2 billion, I think, in fines issued under the GDPR at the moment, maybe a bit more. Sounds like a huge figure. That's 1.2 billion in 5 years. But then you do the breakdown of that, and it's made up mainly of like 99% of 3 major fines: Amazon, Google, and Meta. There's a kind of thematic there of where those organizations originate from and the sector in which they are, right? And also the size and scale of those businesses. Below that, there has been far less financially sanctioned or sort of headline figure enforcement actions. There have been some. We've sort of seen, 40 odd million for H&M. We've seen a data security fine for BA that was in sort of 20 million. So they're not insubstantial figures. But in relation to the amounts of data being processed and data being transferred, we've seen very little at the high end of the potential sanctions. What we're seeing far more of from the regulators now is actually focusing not so much on these big fines, but on taking what we call the sort of additional measures, they can actually say, right, you have to stop processing. Because, for example, your international transfers are not valid, therefore you can't make that, you can't implement that process. So you have a stop processing order. I think that's far harder for an organization to deal with. If you get a big fine, it probably makes for a bad week, bad quarter, possibly a bad year, depending on the level of fine. If you get a stop processing order, you will probably be given 3 months in which to rectify, which is an incredibly short time. And if your entire business model has been constructed over a long period with certain mechanisms in place, to pivot those in such a short time is, incredibly challenging and could actually be fatal to the business in a way that a fine isn't. And we've certainly seen regulators going more and more down this additional measures route.
So, Rohan, I want to kind of reinforce what you're saying there, because as you know, in the US, we're now up to 12 privacy laws that have been passed. And usually the big road to hoe here is there a private right of action or not? And that's an imperfect solution, because normally the only people who benefit from a private right of action are the class action lawyers, not the three of us who might get $2.97 for whatever happened. But you bring up a really interesting point, which I think you're saying is, if the regulators say, you know what, we're not going to fine you, but we're going to make it so that if in 3 months you don't figure out how to process this data differently or do it properly, you're just not going to process it. And then that's a potential huge issue for the company. But as part of that is, do you think that there are enough resources that the EU has to enforce the law? And if not, where do they get the money in really constrained budgets across pick your country, including the US, to have the necessary resources to make all the rules we're talking about today and more broadly on our show really have teeth?
Yeah, look, it's a challenge. It's always going to be a challenge. I don't think any regulator will ever tell you they've got sufficient resources and sufficient firepower to take on, the scale of what they're trying to regulate. But if we look at all of the regulators across the EU in this space, the data protection authorities, they have all grown significantly in the last 5 years. They have all got far better resourcing. They're getting far more efficient at working together on a coordinated basis. So we're seeing, I think, far better enforcement by the regulators. Have they got the ability to do everything? No. Are they always going to pick their battles? Yes. The UK ICO, John Edwards, has made very clear publicly, his target is harm, right? He is looking, if there's a missed I dot or a missed T cross somewhere with somebody's record of processing, that's not going to be his big area of focus. Where he's seeing real harm in data protection, non-compliant, that's where he'll be focused. And where that, the bigger the scale, the more people impacted, that's probably going to be another one of the criteria for targeting, I would say.
A lot of the focus is often on consumer data. However, employee data is also in scope. Can you talk a little bit about how HR data is treated under the data privacy framework?
Sure. So I think HR does have a specific focus and is called out under the framework. And I think one of the reasons being that HR data has always been, one of the sort of mainstreams of transatlantic data flows, because there are so many multinational organizations headquartered in the US that, for commercial efficiency and simplicity, like to centralize their HR data. It can be used for many functions, talent management, payroll, efficiencies, etc. So that data is centralized. Within that data set is usually quite a lot of sensitive data. And by that, I mean data relating to, sort of race, ethnicity, medical conditions, sex life, and sexuality, criminal convictions, trade union membership, religious or philosophical beliefs, because that's what you sort of can have in an HR file. So you've got quite a sensitive data set from the start. And I say, it's one of the ones that we've seen historically that, organizations really, for commercial purposes rather than for necessity, they could leave it in the UK or the EU and process it there, but it's more efficient if they can sort of coalesce it and centralize it. And so for this reason, we've seen a lot more focus on the HR data. When you're making your certification, you can do it for either HR data or HR and non-HR data. So it's called out that way, and it was always called out that way under the previous frameworks as well. And one of the key areas is, like, if you're doing that, it's making sure that all of your employees know what data is being centralized, why it's being centralized, who it's being shared with. Is it being shared with, local insurance and benefits companies or payroll providers? All of that information needs to be clearly communicated back. And I think that's one of the concerns. Is it's always great to centralize your systems, but it's because it's not a necessary requirement, and it's really just a commercial efficiency position, that you've got to begin in making sure that employees are clearly aware of what's happening with their data.
Thank you for clarifying. And that makes a lot of sense. Transparency, notice.
Always important.
Yes.
So some people say that because there's been Schrems 1, 2, we're going to get, I guess it'll be a trilogy. We'll get Schrems 3. And there's no point in certifying. So what do you say to companies who that's their thinking at the moment?
Yeah, look, interesting challenge. I think we will get Schrems 3. Question is whether Schrems 3 will be as successful as Schrems 1 and 2. Now, the sequel follow-ups are always challenging, right? And so it will be. I mean, I think we have seen sort of significant steps forward looking at the executive order, looking at the new court for redress that's been established in the US. Yeah. Just taking those steps, I think, is pretty significant, because those two steps were totally focused on the issues that came out of Schrems 1 and 2 and the challenges that had come up before that. Now, will this be the perfect solution? It's already had its doubters and its critics. The European Parliament wasn't fully supportive as the draft adequacy decision was going through. But it's a step forward. And, we've seen that the EU Commission saying, well, look, let's give this some time. Let's see how effective the redress mechanism actually is in practice before, we're looking for the court to challenge or expedite any challenge that's filed with it. Let's see if what we've got in place now with the changes that are made actually works. Now, I would be hopeful that it can be. I think there is a great political desire on both sides of the Atlantic to ensure that this framework does succeed. And it's not just for the EU, because we know that the UK is going to target on the back of this, seeing as we're now no longer a member of the EU. And Switzerland will again, use its sort of linking mechanism to leapfrog on the back of the data privacy framework. So I think it's really important politically that we have something in place, because the uncertainty that was created when both Schrems prior cases were successful, and we lost the safe harbor, we lost the privacy shield. It did throw organizations into a period of instability. And so if we can get longevity with the framework, it's going to be helpful for businesses. And hopefully there'll be, I think at the end of the privacy year, with about 5,300 US organizations signed up, they're hoping that the robust nature and the longevity of the framework will mean that far more US entities sign up to the framework, to the new framework, which is really, I think, will be a helpful thing, because it does make data flows far easier.
We always like to ask all of our privacy professionals who are likely thinking about privacy all day long, just like we are. When you were out, what is your favorite privacy or security tip that you might offer?
So I was thinking about this, and it's a good one. My favorite thing that I do at the moment is whenever I sign up for anything new, my username is usually linked to the service that I'm signing up to. So if, let's say I'm signing up to Joe Sandwich Shop, my username might be Rohan Joe Sandwich Shop Massey. And then I get to see where my marketing emails come from, which is usually quite interesting.
That's a very creative tip. I like that one. I haven't heard that one yet. I like it.
But Rohan, what email do you use? Because they're going to send it to that. Are you creating like a new email or?
No, they send it to that, but they'll always address it with your username. So it comes through with, hey, Rohan Massey, Joe Sandwich Shop, but it's for a totally different product.
Right. Okay. So you're able to trace who they're sharing, or okay, got it. That was a novel tip.
I know. I haven't heard that one.
Very novel tip. Well, thank you for that.
Yeah, because we learn, and then we share, and then everyone listening gets to learn something new.
Indeed.
All right.
So Rohan, when you're not advising on global privacy and cybersecurity issues, what do you like to do for fun in London?
Yeah, maybe not so much in London, but something I've taken up recently, which is cold water plunging. So basically, I immerse myself in freezing water. Like many athletes do at the end of their training sessions, I'm not an athlete though, but I do throw myself into freezing water, which is supposed to be very good for my nervous system, but it also clears the mind very quickly of anything that may be troubling me or any privacy issues I should be thinking about and want to clear out of my mind.
Dare I ask how long these plunges last? How long do you have to do it to get a clear mind?
To do it to get a clear mind, about 5 seconds, but I'm up to about 5.5 minutes at the moment.
Wow. How cold is this water?
About 2 degrees.
I think I would last about 5 seconds. That's really cold.
What do you mean? It's like in the winter when people will go in the plunge in rivers and whatever.
Yeah, I call those polar crazy people.
Okay, well, I guess they're just polar different people from you.
Well, Rohan, this has been very educational and insightful. We're so grateful that you came. If people would like to learn more and connect with you, where should they go?
They can come to the website, ropesgray.com, and my bio is on there, and I'm more than happy to answer any questions that people have.
Wonderful. Well, thank you so much. This is definitely a fast and complex topic that will continue to evolve.
Great. Well, thank you very much for having me. It's been a pleasure.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.